Okay, in our continuation of our discussing of terms of engagement of an audit, we're going to be going through some issues we might find with management-imposed scope limitations that might require a disclaimer of opinion. And this is in section 210.07. And it says that if management or those charged with governance impose a limitation on the scope of the auditor's work in the terms of the proposed audit engagement such that the auditor believes the limitation will result in the auditor disclaiming an opinion on the financial statements as a whole, the auditor should not accept such a limited engagement as an audit engagement. So if we're approached by a client, they want us to audit a very small scope of the company, and such that it leaves a very large material piece unaudited that would inhibit our ability to provide an opinion on the financial statements as a whole, we would disclaim an opinion to say we have no opinion on whether there are material misstatements in the financial statements as a whole. And so what this tells us is that if that's the case, then we really have no point of doing the audit in the first place, and we should not accept that engagement. However, there may be cases where we do accept that engagement, and if management or those charged with governance of an entity that is required by law or regulation to have an audit imposes such a scope limitation and a disclaimer of opinion is acceptable under the applicable law or to the regulator, the auditor is permitted but not required to accept the engagement. So let's go down to some further discussion of what all this encompasses, and that's in the explanatory material sections A18 through 19. Okay, so here's the explanatory material on AUC section 210.07. And it says that scope limitations may be imposed by management or by circumstances. So those are two different situations. And so there may be times where we could accept the audit engagement even though there is a scope limitation. And that might be where the restriction imposed by management leads us to a qualified opinion. So not necessarily that the limitation on the scope was so severe that we had to disclaim an opinion, but maybe the scope was limited only slightly to where we could get by with a qualified opinion. So we would be able to accept that engagement. And also, there might be a restriction imposed by circumstances beyond the control of management. And an example of that one might be the audit of employee benefit plans. And for employee benefit plans, there's typically a disclaimer of opinion in those engagements because the auditor typically doesn't audit the fair value of the investments within the employee benefit plan, which represents a very material piece of the plan. So he basically has to disclaim an opinion on the financial statements as a whole because he doesn't audit a very material piece of the financial statements. And what's different about that is that it's acceptable under the law and the regulator, such as ERISA. And so in that case, auditors neither precluded from accepting nor required to accept that engagement.